Good morning, everyone. I hope everyone is doing well today. Let's see, it's right at 9 o'clock. This is the Orca B status calendar. I'm Judge Eric Morrow, and we'll be presiding over court today. It's my understanding that all of these cases are either set for a final plea or have been on our calendar previously, and we're given a second opportunity to be present today. So given that, let me just go ahead and call the calendar and see who we have with us this morning. Position number 1, Roberto Arias. Roberto Arias. Good morning, Ms. Githia. How are you today?
Good morning, Your Honor. I'm well.
Who's with you? Are you anyone with you today?
Miss Riley and Miss Marshall Story were supposed to be on.
Yes, Your Honor, I'm here.
Okay, good morning, Ms. Riley. Let's see, Position 1, Mr. Arias doesn't seem to be present this morning. What's the state's pleasure?
Your Honor, I apologize. On which calendar? I have Tyrone Christopher as number 1. Or is this Orca B status calendar?
Yes, it is. I have Tyrone Christopher on my calendar as number 2.
Yeah, we don't have the first position, Judge.
No, Your Honor, I apologize.
All right, it's my understanding that another calendar went out, so I apologize about that. So we'll do the best that we can as far as the numbers and the names go.
Your Honor, with the court's permission, can you provide me with the case number on Mr. Arias?
Yes, Mr. Haddad, it's case 20 CR 003632F.
Thank you, Judge. Thank you.
Given that he's not on your calendars, I'm gonna hold on that case, and I'll decide what I'm gonna do at the end of the calendar. I just want to make sure that he received proper notice.
Thank you, Your Honor. However, I do see someone with their hand up. I'm not sure if that's Mr. or Mrs. Arias. V60 FinQ 5G, it looks like.
Yes,
Yes, what's your name?
I'm Carlton. I'm Carlton Cuthbert. I just wanted to.
Okay, I'm in the process of calling the calendar, sir. So once you hear your name, if you'll just let me know that you're here, okay? So if you will wait to hear your name, okay? Since our calendars are a bit off, I'm just going to call the names without the numbers. Please let me know if you have someone that's on the calendar that's not in order. Tyrone Christopher.
Good morning, Your Honor. Wanda Gant standing in for Patrice Helen. He is present also on the Zoom call.
Yes, what are we doing with Mr. Christopher today, Ms. Gant?
We will be moving forward with a negotiated plea.
Okay. Demico Coleman. Is Mr. Coleman present? What's the state's pleasure?
Yes, Your Honor, I have that he also failed to appear on June 29th. State would be asking for a bench warrant.
Okay. Bench warrant granted. And now here you are, Mr. Colbert. Carlton Colbert. You have to unmute yourself, Mr. Colbert, so we can hear you.
Unmute. Can you hear me now?
Yes, I can hear you, Mr. Colbert. Good morning, sir. Let me just
Yes,
advise,
sir. Good morning.
do you have an attorney, a private attorney, or would you like to seek the assistance of a public defender today?
I have an attorney.
Okay, what's your attorney's name?
His name is Thomas E. Stewart.
Did Mr. Stewart know about your court hearing this morning?
Yes, sir. I talked with him earlier. He said he had a situation that was that was going on in Henry County, and if he said to ask if I could a court this afternoon on a continuance.
Okay, so hold on for me, Mr. Colbert. I'll come back to you, okay?
Yes, sir.
And if we can find out if there's a entry of appearance for Attorney Stewart at the end of the calendar. Thomas Gibson.
Good morning. He is on the call. Good morning. He's on the call. We are ready at the court's pleasure for negotiated plea. I believe Ms. Johnson has all the paperwork and we're ready to go when you call us.
Okay, I'll take you first at the end of the calendar, Mr. Cohen. I do have your paperwork here and we'll get that plea taken as soon as possible, okay?
Sounds great. Thank you.
George Giles.
Oh, yes, Your Honor.
Good morning, Mr. Giles. How are you today? Good. Ms. Gant?
Yes, Your Honor. Good morning. Wanda Gant, standing in for Patrice Helen, and we will be moving forward on a negotiated plea.
Okay, thank you, sir. You can have a seat. Sierra Hosey.
Good morning, Judge. Ms. Hosey, I'm pretty sure I saw her a second ago. We're ready for a plea as well. I just emailed this morning, about 20 minutes ago, the paperwork, so we're ready whenever the court is, Judge.
Okay, very good. Good morning, Mr. Haddad. I do have the paperwork.
Good morning, Judge.
Indeshu Howard.
Yes, yeah.
Yes. Good morning, Ms. Howard. Do you have a private attorney in this matter?
What is this pertaining to exactly? I'm sorry.
Ms. Howard, you've been charged in case 20 CR 004194F for simple battery family violence. This charge carries a maximum penalty of 12 months in jail and or $1,000 fine. It's my understanding that you've been on the calendar before in regards to this matter. And my question to you this morning is, do you have an attorney representing you? That's the first question. Is that in the affirmative?
No.
Okay. Would you like to seek the assistance of a public defender to see if you qualify today?
Yes, but in this matter, I thought that the last time I had a hearing, it was supposed to be dismissed, or like it was nothing further to do.
That's not the case, Ms. Howard. The state has not dismissed this charge. If you would like to speak to a public defender today to see if you qualify, I'm happy to give you that opportunity. If you would like to dispose of it in some other way by speaking with a solicitor in this regards, then I'm happy to do that also. I would advise you that you have a right to remain silent and that anything you say can and will be used against you. How would you like to proceed, ma'am?
That's fine. I speak with a public defender.
Okay, so what I'm going to need for you to do is we're going to put in the chat how you can go about qualifying for a public defender today. If you will also put your information in the chat so someone can get in touch with you regarding this matter to see if you qualify. Okay.
Okay.
All right, we'll be back with you, ma'am. Thank you. Thomas Hutchins.
Yeah, because I don't do.
Ms. Howard, you're going to have to mute yourself, please, ma'am. Thomas Hutchins. What's the state's pleasure?
Ms. State would move for a bench warrant, Your Honor. He also failed to appear on June 29th.
Bench warrant granted. Marquavius Jones.
Good morning, Your Honor. Wanda Gant, standing in for Patrice Helen. Regarding Mr. Jones, he was to follow up with our office for our services on July 1st. Our office did reach out to him. We did not get a response. We called again on the 30th, again with the wrong number, Your Honor.
What's the
Good morning. This is Mr. Jones right here.
Yes, Mr. Jones, can you activate your camera for me, please?
Yes, sorry about that. Good morning.
Good morning, Mr. Jones. Did you make application with the public defender's office?
When I was in the process, my phone ended up getting messed up, so I haven't had a new phone. I just got one actually probably about a couple days to a week ago, honestly.
Okay, so there's more than one way to apply for the public defender. I mean, if it were me and I did not have access by phone, I would just come down to the court and see what I could do to fill out the paperwork so that I could be prepared when my court date came available. I'm happy to give you the opportunity to see if you qualify for the services of the public defender today, if that's what you desire.
Yes, sir.
All right, so if you will also go into the chat, begin filling out the paperwork and put your information in the chat so that someone can get in touch with you, please.
Understood.
Okay, very good. Thank you, sir. Tiara Jones. I have down that this was a return to sender.
Yes, Your Honor, I'm here.
Good morning, Ms. Jones. Did you have a private attorney representing you in this matter?
Not yet, Your Honor.
And Your Honor, I apologize for interrupting, but she did not qualify for the Service Public Defender's Office. She was on the calendar on the 29th of June, Judge.
Okay. Have you sought to obtain counsel, Ms. Jones?
Yes, Your Honor, I can't afford the prices that the lawyers are charging right now, but I have attempted to try to find one.
Okay. You've been charged in case 20 CR 003855F with simple battery family violence. This charge carries a maximum penalty of 12 months in jail and/or $1,000 fine. You do have the right to have an attorney present to represent you in this matter. You have been on a calendar before regarding this charge. What would you like to do today, Ms. Jones?
Your Honor, if I may, this is also a dual matter with Traviance Swan. I don't believe he's on the calendar, but I do have.
He's on the calendar, I believe.
Okay.
That's how I got my information to come today, because I
Your
got a
Honor,
return defender.
that is position number 18, Swan, and he also did not qualify for the Service Public Defender's Office, Judge.
Okay. Is this Mr. Swan under the iPhone?
Yes, this is Travion Swan.
Okay. Do you have an attorney, Mr. Swan?
I'm starting to get a lawyer right now. If I can just ask for a little more time, I will have one by then, if that pleases the court.
Okay. So I am going to, for both of you, you've been on a calendar before. We do want to move these cases forward. I know that you're trying to get a lawyer. I'm going to give you one additional opportunity, Ms. Jones and Mr. Swan, to obtain counsel to represent you in this matter. I'm going to reset you to September 28th at 9 o'clock. Okay.
Thank you, Your Honor. Is there any way, anywhere I can go and find a valid information on possible lawyers in this matter that are within a good price range?
You can call the bar and they will have a list of attorneys that may be able to represent you, Ms. Jones.
I appreciate your advice.
Let's see, for Ms. Jones and Mr. Swan, we do not have your updated information. So what I'm going to need for you to do is go ahead and put that into the chat. If you can put your address and your email information and your phone number for us, okay?
Yes, sir.
All right, so you're gonna.
Thank you.
All right, so come back on for you, Ms. Jones. So let me see you. All right, so I need for you to do that. Once you do that, you're gonna get notification of your next hearing date, which is gonna be September 28th at 9 o'clock, okay? I'm giving you verbal notice at the present time, and I'm going to make note that I'm giving you verbal notice, but you will also get written notice of this date. If you come back without an attorney, what I'm going to need for you to do is I'm going to need for you to tell me how you want to proceed. You can either plead guilty, not guilty, request, and if you plead not guilty, you can request a bench trial, or you can request a jury trial. If you request a bench trial, that will be before myself sometime in the very near future. If you request a jury trial, the case will be returned to the division judge and you'll get notification of when your jury trial will be, okay?
Yes, Your Honor.
Do you have any additional questions for me this morning?
No, sir, I appreciate your time.
You're welcome. So go ahead and put your information into the chat, and then once you do that, you're free to go.
Thank you.
You're welcome. Luke Marks.
Good morning, Your Honor. Wanda Gant, standing in for Patrice Helen. I would ask the court for a reset as Mr. Marks is hospitalized at this time and the BHDT is pending.
Okay, this is the 28th work for you, Ms. Gant? Of
Yes, it
September?
does, Your Honor. Thank you.
Okay. Chad Owens.
Good morning, Your Honor. LaTanya Askew for Chad Owens. How are you?
I'm doing well, Ms. Askew. Good morning. I hope you're
Good
well.
morning.
What are
Thank you.
we doing with Mr. Owens today?
I sent over to Ms. Marshall Story, Attorney Marshall Story. I sent over the signed plea paperwork with my client's signature and my signature. So we're ready to move forward today. My client is on the line. So I guess once you finish the calendar, I'll await for the court.
Okay, very good. Thank you, Ms. Askew.
Thank you.
Ms. Marshall Story, you have that paperwork?
Your Honor, actually, I sent the paperwork, but Ms. Askew, I'm sorry, I don't have the signed paperwork.
I just sent it 2 minutes ago.
Oh, that might be why.
Right.
Your Honor, if I can have a moment to review while you continue your calendar, and I'll forward that to which litigation manager?
Ms. Johnson's with me today, Beverly Johnson.
Okay, thank you.
All right,
Thank
you're
you.
welcome. Alan Pittman.
Good morning, Your Honor.
Good morning, Mr. Pittman. Let's see. Do you have a private attorney?
I don't. I'm still in between two different lawyers. I haven't retained one yet. I was asking, could I get more time?
And Your Honor, he also did not qualify the last time he was on the calendar, Judge, on the 29th of June.
Okay. What's the issue, Mr. Pittman?
Just finances right now, but I'm seeking some help from a family member to help me obtain a judge. So I should have one pretty soon.
Okay. All right. So I'm going to reset you, Mr. Pittman, to September 28th. That should give you enough time to obtain counsel. If you come back on September 28th and you do not have counsel, you're going to have to be prepared to let me know how you'd like to move forward. You can either move forward by speaking with the solicitor and getting an offer and entering a guilty plea if you like, or you can enter a not guilty plea. Your case, if you request a bench trial, will happen before me in the not so distant future. If you request a jury trial, it will be returned to the division judge. Okay. You have any questions for me?
No, I don't.
Okay, I'll see you back on September 28th. If you do get counsel prior to that time, please have your counsel enter a notice of appearance so that we know that he or she has been retained by you. And please
Okay.
be in touch with the solicitor's office so that they can be prepared to move forward prior to the September 28th date, okay?
Okay.
All right, so the quicker you get that done, the quicker that you'll have representation and they'll be able to properly represent you.
Okay, thank you. I appreciate it.
You're welcome. I'll see you back on September 28th, Mr. Pittman.
Okay.
Jordan Quinez. Is that your client, Mr. Kelbaugh?
Yes, it is, Your Honor. He is on, it says Jordy. But if I could have a moment to speak with Ms. Marshall Story after the call of the calendar, I was not able to get the documentation that you requested, Ms. Marshall Story.
Okay, I'm happy to give you that opportunity, Mr. Kelbaugh. So we will hold for your announcement. Also, Mr. Kelbaugh, I do have a return to sender for your client. If you can make sure that we have his proper address so that if necessary in the future that we do have correct information.
Yes, Your Honor.
Thank you. Tashenka Rucker.
Here.
Your Honor, that is my case. I just need to speak to her for a few minutes before I can make another announcement. Perhaps we can do a breakout room if possible. If not, I'll just call her, Judge. But can hold for my announcement, Judge.
Okay, I'm happy to do a breakout room, Mr. Haddad.
Thank you, Judge.
Richard Schneider. Richard Schneider. I know that he has counsel. I'm gonna
Yes,
hope.
his counselor is Mr. Weiner, Your Honor, but I have not had contact with him.
Okay. We'll see if we can contact him at the end of the calendar. David Soto.
President, Your Honor.
Good morning, Your Honor. This is Steve Cowan for Mr. Soto. Ms. Githier and I have this worked out. However, I am due on 3 other formats in Superior Court. I just wanted to respond to this calendar now, if I could, and get to 3 other judges, if I could.
Can we take that plea right now, Mr. Cowan?
It's fine with me, Judge, if the
All
court
right,
can
so
do it.
yeah, let me do that so that we can get you get you out of here.
Your Honor, if I have not received the signed plea paperwork, did you send that to Ms. Johnson, Mr. Cowan?
I don't know, Ms. Githier. I'm not sure what we did, frankly.
Do we have that?
I don't have it yet, no.
Okay.
However, you do have it?
I only have a null price for one of the counts, Mr. Cowan. I do not have the paperwork.
Okay. Judge, it's perfectly fine with me if the court would allow us to enter the plea and either Ms. Githier or the court sign on our behalf with our express permission, as some state courts have done and are doing.
Ms. Githier, I don't know what the policy is of the solicitor's office.
Well, I know the last time we were on the calendar for this case, you were not comfortable with filling out the form, Your Honor.
Okay.
That's why it was reset.
All right. So do you have the paper? I'm sorry, Ms. Githier. Do you have the paperwork, the signed paperwork?
I do not.
So, Mr. Cowan, we're going to have to get Ms. Githier the signed paperwork, and then she's going to have to get that to me.
In that event, Judge, I'm going to have to ask for a reset date.
All right. So,
Your Honor, if I may, just
yeah,
for
Ms.
a
Riley.
moment, Ms. Githier, if you're comfortable sending the paperwork to Ms. Johnson, and that way it will have the recommendation on there, and all Judge Morrow would have to do would sign the defendant's name with express permission from his attorney. If you're comfortable doing that.
I mean, whatever Your Honor is comfortable with.
Okay. Well, do you have any paperwork, Ms. Githier, at the present time?
I do.
Okay. So why don't you send that to Ms. Johnson, and then we'll move forward from there.
Okay.
So hang on for us as long as you can, Mr. Cowan. I'll take you once I get that paperwork, okay?
Thank you, Your Honor. If I leave and come, I'll come back, all right?
Very good, thank you.
Thank you.
We've already dealt with Mr. Swan. He will be reset till September 28th. Emmanuel Taylor.
Your Honor, I spoke with the attorney, Mr. Edward Adams, this morning. He's in courtroom F, and he's going to try to make his way over as soon as he's out of that courtroom.
Okay, so we'll hold for his announcement. Felice Thomas.
Good morning, Judge. That is my case. We're going to request a bench trial on this case, Your Honor.
Okay, the bench trial is going to be October 26th at 1:30, Mr. Haddad.
All right, thank you. October 26th, Judge?
Yes.
Okay, thank you.
Okay. Michael Veldabell. I see
Hi,
that.
Your Honor. Hi, Your Honor. My attorney is present on the call, I believe.
Mr. Wolf.
He, in the chat earlier, he said he was in another courtroom. He is.
Okay.
His report, please.
So we're going to hold for his announcement, sir. So we'll be back.
Okay. Thank you, Judge.
You're welcome. Michiel versus O'Neillia.
Your Honor, I believe, I could be wrong, but I believe it's a companion case to position number 20. But I'm not sure, but there's a private attorney that's listed.
But I have Carol Lewis. Have we heard from Mr. Lewis?
I have attempted to contact the attorney. I have not received any responses.
Okay, I'll hold till the end of we have a return to sender for the defendant. I'll hold until the end of the calendar to see if we can contact Mr. Lewis. Betty White, know that this is Miss McLeod's case, and she's asked that.
I'm here.
Miss White?
Mm-hmm.
Yes, where are you, Miss White?
Right here.
Okay, there you go. All right. We've been in contact with your attorney. She's asked me to hold for her announcements, Miss White. So if you can hang on the line for us until we hear from Ms. McLeod, okay?
Yes, sir.
Thank you, ma'am. Kamara Woods.
Your Honor, that would be my case. The number that I've had for her seems to have been disconnected. I've not had contact since the 29th, which is when she applied and qualified. I don't know where she is. I don't believe she's on. Hopefully she got the notice, but I had no way of contacting her.
We do not have a return to center regarding her, Mr. Haddad. She has been in court before, it's my understanding. What's the state's pleasure?
The state will request a bench warrant, Your Honor.
At this time, since we don't have a return to sender and she has been on the calendar before, the bench warrant will be granted.
Thank you, Judge, and I'll see what I can do if I'm able to track.
Okay, if you can, Mr. Haddad, I'm happy to withdraw the bench warrant if she wants to appear.
Thank you, Judge.
Yes. Mr. Coleman. Good morning, Mr. Coleman. Let's see. Do you have a private attorney in this matter?
No, I don't really think that I.
Well, Mr. Coleman, you've been charged in case 20 CR 004176F with simple battery. This charge carries a maximum penalty of 12 months in jail and/or $1,000 fine. Okay, so if you would like to see if you qualify for the services of a public defender today, I'm happy to give you that opportunity. We have one that's here that can assist you if you want to go down that road. Otherwise, you'll have to let me know what you want to do as far as this matter is concerned.
Okay, I did go to court before this.
Okay.
A year ago, I did the Skype.
So if you would like me to see if you qualify for the services of the public defender that can help you out this morning, I'm happy to give you that opportunity.
Okay.
Would you like to do that?
Yeah.
Okay, so if you'll just have a seat, someone will be with you.
Your Honor, my apologies. What case number was that, or?
I'm not sure what number it is, but it's
Position number 2. Position number 2.
Position number 2. Okay, thank you. And Your Honor, I need to revisit a position when you have an opportunity to do that.
Okay, and I saw that Mr. Arias position number, well, on my calendar, he's position number 1 has joined us. Roberto Arias, I see you there, sir.
Yes, sir.
Good morning, Mr. Arias.
Good morning.
Do you have a private attorney representing you in this matter?
No, I don't, Judge.
Okay. Would you like to seek the assistance of a public defender to see if you qualify this morning?
Yes.
Okay. So what I'll need for you to do, Mr. Arias, is to go into the chat and put your information in the chat so someone can contact you. And given that you're in a car, I don't know if you're going to be able to fill out any information for the court, but if you can put your information, and I'll have a public defender speak with you, okay?
Your Honor, I apologize. If you could give that case number one more time.
Not a problem. It's case 20 CR 003632F.
Thank you.
Ms. Marshall Story, you had an announcement?
Yes, Your Honor, regarding position number, my position number 12, but it's Chad Joseph Owens with Attorney Latanya Askew.
Yes.
I've had a chance to review the paperwork, but Ms. Askew actually filled it out as a NOLO. And my apologies, Ms. Askew, but I am unable to take this battery family violence plea as a NOLO.
And why is that?
Changes this, excuse me?
And why is that?
Because our office policy is not to do that. And that's not something that we discussed. We've had several conversations regarding trying to work this plea negotiation out. That wasn't a specific question that you asked me. If you had, I would have let you know. I'm unable to take a battery family violence plea to a NOLO.
Judge, if we can pre-try the case with you, if you don't mind.
There's nothing more to pre-try with me.
Ms. Marshall Story, I'm speaking to the judge.
Yes,
Judge,
that would mean that you would be taking a
Judge
blind
Morrow,
plea.
Judge Morrow,
hold
can
on.
we pre-try the case with you?
Yes, I'm happy to entertain.
Thank you.
It would be a blind plea, Your Honor. So obviously there's nothing more for me to say about it.
But I'm not speaking with you. I'm speaking with the judge. I'm directing my question to the judge. I'm
Okay.
sorry, Judge.
That's fine, and I'm happy to do that. So let me get to the end of the calendar, and which we're pretty much at. Then I will get back with you, Ms. Askew and Ms. Marshall Story. Thank you.
Thank you, Judge Morrow.
And let's see. In that regard, I don't think we have anyone from pretrial on. Can we contact pretrial just to say that I'm going to need their assistance this morning regarding a history?
Yes.
Thank you.
Can I give an announcement real quick?
Yes.
Good morning, everyone on Zoom. You must be physically there. No cameras off. If you have a bonnet or a scarf on your head, you must take it off. Thank you.
All right. So let me go back first to David Soto. And I'm not sure if Mr. Cowan is still with us.
Here, Your Honor.
I see you there, Mr. Soto. Is Mr. Cowan with us? Okay, so when Mr. Cowan does come back, I've got the paperwork. None of it's completed. It's not the guilty plea. The questions are not circled. I'm gonna request that the defendant completely fill out this paperwork before we take this plea, which probably means that it'll be reset to another date. But I'll address that with Mr. Cowan when he returns. Okay.
Okay, Your Honor.
All right. So, yes, I take it that you're getting your pleas ready.
Yes, Your Honor.
All right, Mr. Cohn. Let me take Thomas Gibson's plea so we can get that done. Do we have that patient? Yes, I do.
And Your Honor, is it possible to for me to be placed in a breakout room to speak to my client while you all handle the plea? And that would be Ms. Rucker, position number 15. If not, I understand, Judge.
Okay, no, you're fine, Mr. Dodd. Can we place Mr. Dodd and Ms. Rucker into a breakout room, please? Let's see, for Mr. Gibson, who's handling that? Ms. Riley?
Yes, Your Honor.
Okay, so Ms. Githier or Ms. Marshall Story, do you all need to be placed into a breakout room with anyone at the present time?
No, I do not, Your Honor.
I don't believe so, Your Honor, since Miss Attorney Askew is seeking a blind plea. I don't believe I have anyone else I need to speak with.
I didn't state that I was seeking a blind plea. What I asked was if we could pre-try the case with Judge Morrow. So don't put words in my mouth. Those are your words.
Okay, so hold on, let's, Mr. Kelbar,
I need to speak to Ms. Marshall's story.
Okay, so we'll put Mr. Calabon and Ms. Marshall's story into a breakout room.
Thank you.
Your Honor, I apologize really quickly. In terms of Mr. Cowan's plea, again, I'm not sure if the court is comfortable, but just trying to move the case along. If when Mr. Cowan comes back, he can go into the breakout room with his client to go over the questions and it just be verbally on the record that he understands his rights. I don't know if the court would feel comfortable circling those.
I'll thank you, Ms. Riley. I'll have the conversation with Mr. Cowan when he returns.
Yes, Your Honor.
I prefer that the paperwork be filled out and signed,
Understood.
properly done. Because if we get into the habit of doing that, then I don't want to go down that road where people have not completed the paperwork, especially when we've given them an opportunity at a prior hearing.
Yes, Your Honor.
Thank you, Ms. Riley.
Your Honor, one more thing. Ms. Howard. Ms. Howard.
Yes.
Ms. Howard. You know you can't be driving. You need to pull over to a safe position.
Your Honor, I'm going to go ahead and join the breakout room with Mr. Attorney Kilball.
Okay, thank you.
All right.
All right. All right. Mr. Gibson. We're getting feedback from some.
Let me turn the lights off. Yeah. I'll turn the lights off.
Okay, thank you. Okay. Yes. Good morning again, Mr. Gibson.
Good morning.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, thank you. You can put your hand down. Put your hand down. Okay, Ms. Riley?
Yes, Your Honor. On September 14th.
We're gonna have to get that. I'm sorry, we're gonna have
No
to get
problem.
this repaired. Can we figure out what's going on here? Try it again, Ms. Riley.
Okay.
Thank you.
You're welcome. On September 13th, 2019, officer was leaving a Shell gas station on 6185 Windward Parkway in Fulton County and observed a white Chevrolet Silverado, later learned to be driven by Mr. Gibson, past the exit. And due to an unnecessary pause, the officer began observing Mr. Gibson. The truck proceeded on Windward Parkway, running over the middle median curb, coming out of the gas station in the process. The truck then approached Union Hill Road and came to a stop, excuse me, at a green traffic light. The officer made a few more observations and then initiated a traffic stop. And Mr. Gibson was advised the reason for the stop. And he was told that he was trying to find a friend's house and he got lost. The officer at that time observed an odor of an alcoholic beverage coming from his breath or person and asked if he had been drinking. He said he had a beer or two. The officer then asked if Mr. Gibson would participate in voluntary sobriety testing in which the officer observed several clues and determined at that point that Mr. Gibson was under the influence of alcohol to the point that it was less safe for him to drive. The state's recommendation is for count 1, DUI less safe, 12 months to serve 24 hours credit for time served. Upon arrest, the balance probated, a $300 fine, 40 hours of community service, the alcohol and drug evaluation, any treatment that is recommended, a risk reduction program, to have attend 1 victim impact panel, and count 2 will be no frost, which I will send at the conclusion of the plea, Your Honor.
Thank you.
Yes, Judge, that's my understanding of the plea from Ms. Riley, except there were 2 things that Ms. Riley, we want to make certain he gets credit for time served and released on time served. There's no intention of more jail time. Ms. Riley was in agreement that when he completes everything, which he already has, he's been very diligent from doing his community service, from doing his alcohol and drug evaluation, that his probation become non-reporting. So those are part of the negotiated plea. Mr. Gibson is 42 years old. He's never been in trouble before in his life. He runs a landscape supply company in Hawkinsville, Georgia. He was here, got a big order, celebrated a little bit too much back in 2019. That evening, he was out celebrating and made a bad decision that evening. You won't be seeing him again. We asked that Ms. Johnson transmit the conviction, hopefully today, if possible, to the DDS, and that way he'll be able to get his limited permit. He resides in Hawkinsville, so as far as turning in the license, he can do that to the Department of Driver Services. And Ms. Riley can tell you from her days in Clayton County, the courts never took driver's licenses. They just ordered people to do that down at the DDS and handle it that way with convictions of first affidavits. So we asked the court accept the plea, and once it gets transmitted, he can then go get himself a limited permit.
Okay. Anything further, Ms. Riley?
Yes, that is correct, Your Honor.
Okay. Mr. Gibson, it's my understanding that in case 20 CR 003907F, you wish to plead guilty to driving under the influence of alcohol less safe. Is that correct?
That's correct.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the plea as negotiated. Once you complete the terms, which I understand that you already have, it'll go to a non-reporting status. And we will give you the information regarding the probation today, okay?
Thank you, Your Honor.
Thank you, Judge.
Okay, and we'll need his address so that we can send the information to, okay?
I will type that into the chat. I will put his address, his phone number, and his email, if that works for everybody.
All right, very good, thank you. Anything further on Mr. Gibson this morning?
No, Your
No,
Honor.
if the only thing I would ask is if there is some issue with the transmission to the DDS, we can always get a first conviction affidavit from the court. Ordinarily, when you do this in person, the court would just hand the document to the defendant at that time, but I think this should be fine as long as it's get transmitted within the next 24 hours.
Okay, that's fine with me.
Thank you. I will put that in the chat, and we will speak later. Thank you, guys.
All right, you all have a good day.
Thank you.
Mr. Calabar, is there an announcement?
Yes, Your Honor. I believe Ms. Marshall Story has an announcement. You're muted, Ms. Marshall Story.
My apologies. I was actually trying to complete the no pros. Your Honor, I've had an opportunity to speak to Mr. Kelba both yesterday and today on his authority as a member of the bar. I am understanding that there is I knew that there was a co-defendant in this case, the defendant's wife, and she's been deported. The defendant in this case is the sole caretaker of the children involved. And so for those reasons, Your Honor, and after speaking with my supervisor regarding this case, the state is willing, again, based upon the assurances and the conversation with Mr. Kilbaugh, that the wife is actually has been in ICE custody and has now been deported to Mexico. The state is willing to no process matter.
Okay, so if you'll get us that null
And
process.
I'm sending that over right now.
Very good. Anything further this morning, Mr. Kilbaugh?
No, Your Honor. May Mr. Quinones and I be excused?
Yes, you all have a good day. Good to see you.
Thank you, Ms. Marshall-Story.
My pleasure.
Okay, Mr. Wolf.
Good morning, Your Honor.
Good morning, Mr. Wolf. Tell me your client's name.
Michael Velarde Bell.
Okay, and it's my understanding this is going to be a negotiated plea this morning.
Yes, Your Honor.
Let me see if okay. And who's handling this for the state?
That would be me, Your Honor.
Okay, are we ready to proceed?
Yes, Your Honor.
Ready to proceed, Mr. Wolf?
Yes, Your Honor.
All right. Mr. Bell, can you raise your right hand for me? Do you swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Thank you. Ms. Githia?
Yes, Your Honor. On August 21st, 2019, officer witnessed signs of an impaired driver, later identified as Mr. Michael Velarde Bell, and effected a traffic stop. While speaking to Mr. Velarde Bell, he detected an odor of alcoholic beverage coming from the person, and his words were slurred. When Mr. Bell was asked to exit the vehicle, he was observed walking with a wide gait and appeared unsteady on his feet. And then also he was observed while standing still and facing the officer, he was swayed in place. Based on those observations, the officer placed Mr. Bell, based on those observations, the officer stated that he was intoxicated and placed Mr. Velarde Bell under arrest. The offer is 12 months to serve 3 days, $600 fine, 240 hours of community service, alcohol drug evaluation and treatment, and a risk reduction course.
Mr. Wolf?
Yes, Your Honor. With regard to the time, the discussion I had with the prosecutor was that we were going to ask the court for credit for time served. My client he served approximately 48 hours at the time of his arrest, and we would ask the court for credit for time served for the 72 hours. He has completed his substance abuse evaluation and all recommended treatment at this time, and as well as risk reduction. In addition, Your Honor, I just wanted to make the court aware that he has a prepaid, pre-scheduled trip October 13th through 22nd. And we wanted to be efficient in closing this case and not try to hold it open until after that trip. And we would just ask the court to consider allowing him a trip. I know it's generally probation's discretion as long as he's otherwise in good standing.
I'm sorry, Mr. Wolf, you bleeped off there for a second, so I didn't get your request.
Okay, any of them?
No. Just the part about his trip, October 13th through the 22nd, and your request regarding that.
Okay, Judge. Thank you, Your Honor. My client has a prepaid trip in October, the 13th through the 22nd. And we're asking that the court approve that. It is for personal reasons, but we're asking that the court approve that in light of the fact that we are, trying to get this closed now instead of trying to close the case after that date.
All right, so as far as let me start with the first thing, the 12 months to serve 3 days, credit for time served. How much time are you requesting?
We're asking that the court not give him any additional time in light. Yeah, thank you.
So credit for time, just for the paperwork, 3 days, credit for time served, 3 days.
Yes,
Is that what you're requesting?
Yes, Your Honor.
Do you have any objection to that, Ms. Githia?
No objections.
Okay. And does anyone have any objection to me writing that on the paperwork?
No objection, Your Honor.
No objection, Your Honor.
And you are requesting, and he's done the community service, the ADET, and the risk reduction course?
He has not done all the community service, Judge. He's done everything else.
Okay, how much community service has he done?
I don't know, Judge.
40 hours.
40? Okay, so can he get the remainder of the 200 hours done by October 13th?
Yes, Judge. Thank you.
All right, and so once he gets that done, are you requesting it go to a non-reporting status?
Yes, Your Honor.
Okay, that's fine with me. Is that fine with you, Ms. Githia?
Yes, Your Honor.
All right, so if it goes to a non-reporting status and he gets it done by October 13th, there shouldn't be a problem. And that's fine with me. All right, anything further before I take the plea?
No, thank you, Your Honor.
Good morning, Judge Morrow.
Yes, good morning. I'm right in the middle of a plea. Can I be with you in just a moment? Mr. Velati Bell, it's my understanding that in case 20 CR 003764F, you wish to plead guilty to driving under the influence of alcohol less safe. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, Your Honor.
You can be represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I will accept the plea as negotiated. And when you complete the terms of the all the terms, it'll go to a non-reporting status, okay?
Yes, Your Honor.
Any additional questions or anything on Mr. Velarde Bell this morning?
No, Your Honor. Thank you.
All right. Good luck to you, sir.
Thank you, Your Honor.
Thank you.
Ms. McLeod? Good. No, you
down here, I had said that I was going to be late because I had an in-person.
You're fine, Ms. McLeod.
But I'm here for Betty White.
Yes, and Ms. White.
I haven't had a chance to speak with her yet, Your Honor.
Okay, so would you like to call her?
Yes, Your Honor, and I have my computer, I can always, get on.
Okay, so Ms. White, Ms. McLeod, your attorney is in court with me. She is about to call you, so if you will accept her call when she calls you, okay?
Could you ask her to put her phone number in the chat?
Okay, and Ms. White, can you put your phone number in the chat for us so that she will?
I'm doing it now.
Okay, thank you, ma'am.
Thank you, Your Honor. I will just go open.
Okay.
And I'll probably just get on the Zoom.
Okay.
Your Honor, I have a couple announcements whenever the court is ready.
Okay, go ahead, Mr. Haddad.
Your Honor, on position number 15, Ms. Rucker, she is on Zoom. Judge, with the court's permission, I had been in contact recently with the prosecutor. It's my fault. We may be able to resolve it the next time around. So I would ask for one additional continuance. I understand if the court is reluctant not to, but I would.
No, you're fine,
ask
Mr.
for-
Haddad. September 28th work for you?
That'd be great, Judge. And of course, I'll be in touch with Ms. Marshall's story. And hopefully we can resolve it by then, Judge.
Okay.
Thank you. Thank you, both Mr. Haddad, for explaining that. And Your Honor, yes, that is correct. We are trying to work out an amicable disposition based on facts and circumstances regarding this case. And we hope to be able to do that by the next adjourn date.
Okay, thank you, Ms. Marshall. Sir.
And can Ms. Rucker be excused, Judge?
Yes, we'll see you next time, Ms. Rucker.
And
Thank you.
Any additional announcements, Mr. Haddad?
yes, Judge. Position number 7, Ms. Howard, she does not qualify for the Services of Public Defender's Office, Judge. She's on Zoom. I think she wanted to find out what the state's recommendation is on the record, and depending on what it is, she's probably going to request a bench trial with the court, Judge.
Okay. Are you there, Ms. Howard?
Yes, I'm here.
Okay. Let's see. You're gonna have to get to a steady state for me so that we can talk to you. Whose case is this? Is your case, Ms. Marshall Story?
Your Honor, is mine, position number 7.
Okay. Ms. Howard,
Yes, sir.
are you ready to for the court
Yes,
to? Okay.
Yes, I'm ready. You have my full attention.
Okay, very good. So I'm going to have Ms. Riley put on the record. You've been charged in case 20 CR 004194F for simple battery family violence. What is the state's recommendation, Ms. Riley?
Yes, Your Honor, it is 12 months on probation, a $300 fine, or 30 hours of community service, and 6 anger management classes. And Ms. Howard is to have no contact with Stredrick Walker, the victim.
I'll take it.
Okay, so did you hear that, Ms. Howard?
Yes, sir.
All right, what would you like to do?
She said I could do the 12-month probation or
30
pay
hours.
the fine.
Yeah, or 30 hours of community service. So it's either or.
I do the 30 hours of community service.
Okay, so my first question is, do you wish to plead guilty to simple battery family violence?
No.
Okay, so if you don't wish to plead guilty, then your options are you can enter a not guilty plea, and you can request a bench trial, which will be before me sometime in the, well, it's going to be on October 26th. Or you can request a jury trial and your case will be returned to the division judge and you'll get notification of your jury trial date. What would you like to do?
I would like to go ahead and resolve it. So if I have to plead not guilty, you say if I plead not guilty, then I'm gonna have to come back again?
More than likely, you're gonna have to come back again in either case because you don't look like you're at a place right now where you can fill out paperwork as far as any type of plea goes today. But if you just told me that you're not guilty. So if you're indicating that you're not guilty, your only options are to either have a bench trial, which will be before me, or a jury trial before the division judge.
Okay, so you know what? I'm sorry for being back and forth. I'm just gonna say I'm guilty just to resolve the situation. Go ahead and take the probation or something. I just want to resolve it. However, the best way to resolve it.
I'm not going to allow you to plead guilty just to resolve a case, Ms. Howard. Okay.
Well, I appreciate you for that.
Okay, you've already told me you're not guilty, so I don't want you to plead guilty just because you want to get this behind you, especially since a simple battery family violence is going to be on your record for the rest of your entire life. You understand?
Okay, well, yeah. Okay, well, yes. No, I don't want to plead guilty then.
Okay, so do you want a bench trial or do you want a jury trial?
I do a bench trial.
Okay, so that's gonna be before me, and that's gonna be on October 26th, okay? You're gonna get notice of that October 26th date. You're gonna have to come down to court in person. You need to, if you're gonna hire an attorney, you need to do so by that date. If you don't hire an attorney, you're gonna have to be ready to move forward with presenting any witnesses or any testimony that you have, okay?
Mm-hmm.
You have any questions for me, Ms. Howard?
No, I don't think so.
Okay, so you'll get notification of the bench trial that's going to be on October 26th at 1:30, okay?
Okay, thank you so much. You have a great day.
You have a good day also. Thank you.
Thanks.
Okay, so I see that we have a couple of attorneys that have joined us. Let me see, Mr. Adams, who is your client?
Hello?
I'm sorry, Judge. Were you speaking to me, sir?
Let me take Mr. Adams first, Mr. Lewis.
Oh, absolutely, absolutely. I'm sorry. I was
Okay.
multitasking and didn't hear clearly.
Who's your client, Mr. Adams?
Emmanuel Taylor.
Mr. Taylor, okay. And what are we doing with Mr. Taylor today?
That's a negotiated plea. I am in the courthouse. What courtroom? I can come down there if it's convenient for you.
Okay, have you already filled out the paperwork?
No, that's why I need to come down, I guess, and
Okay.
fill out the paperwork.
And is your client, where's your client?
He's
Oh,
on Zoom.
here? Okay, so I'm in G33, so if you want to come on to G33, we're happy to get that completed.
Okay, thank you. Okay.
Okay. And Mr. Lewis, good morning. Who is your client?
Good morning, sir. My client is Michele Versania. And she may be on by now. I've just sent her the link. We just got it from Mr. Jordan. Judge, this matter is not ready to be disposed of at this time. I have just actually sent a chat to an assistant solicitor general who I see on the line, but I don't even know if that's the right solicitor general. So I would ask the court if it would to permit us a continuance. I will state for the record, I believe you ordered her to take an anger management class as a condition of her bond. She has done that, and I do have the certificate in my possession.
Okay. Let's see. Is this your case, Ms. Marshall-Story?
Your Honor, this is my case.
Okay, so Mr. Lewis, Ms. Githia is the solicitor that's on this matter. I'm happy to reset this till September 28th. That way you'll be able to file any discovery that you need, and will that give you enough time?
It will, Judge. We've already submitted the discovery demand way back when. But if you would please for me, her picture jumped up really quick and I missed her name. Would you please give that to me again?
Miss, who, the solicitor? Is that who you requested? Miss Githia.
Githia. Okay. All right. I know who I'm looking for now in that office. Thank you, Judge.
I sent you an email on August 8th, so you should have an email from me as well.
Okay.
My contact information.
Thank you so very much. I appreciate you for that.
Mr. Lewis, your client's notification was returned to sender. So if you would make sure that we have her proper address so that she gets proper notification in the future.
Understood. I will do just that, Judge.
Okay. Anything further this morning?
Repeat the date and time for me. You know I'm slow, Judge.
No worries. It's going to be September 28th at 9 a.m.
September 28th, 9 a.m. Understood, received. Thank you, sir.
Okay. Thank you.
Have a good day.
Mr. Cowan, I see that you're back with us.
Yes, Your Honor.
None of this paperwork is complete. So what I would prefer to do is I would prefer to have your client complete the paperwork before we move forward with the plea. And I'm happy to reset this to a final plea calendar if that's what you want to do.
I will accept that, Judge. Thank you.
Okay. So, and this is your case, Ms. Githia? I'm sorry, I'm confusing everyone's cases this morning.
This is my case, Your Honor.
Would you make sure that Mr. Cowan has the paperwork so that he can, if he doesn't already have it, so that he can get it to his client and then get it filled out
Yes.
before the next hearing date.
And I could just put on the record that it was sent August 2nd. And prior to that, it was sent, I believe, June 28th, but I will get it resent again.
Okay.
Judge, I'm sorry, if it's already been sent, we can go back and find it. That was just to my email, Ms. Githier.
Yes, yes, it was.
Okay, I don't know if you heard or not, but I had a heart attack. They call it a mild heart attack, but I think mild heart attacks are what other people have. So I've been a little distracted and somehow I must have missed that. So sorry about that.
I'm sorry
to hear that, Mr. Cowan. So we'll reset you to September 28th. Does that work for you?
9/28, I believe so, Judge. It should.
Okay. All right. So if you can just have the paperwork ready, we'll get it done on the first thing on the 28th.
Thank you so much.
Okay. Mr. Soto, we'll see you next time.
Thank you, Your Honor.
All right.
Have a great day.
You do the same. You also, Mr. Cowan. Okay.
Judge, I have a question for you.
Who's speaking?
Emmanuel Taylor.
Okay, hold on, Mr. Taylor.
Position 19, Judge.
Yes, Mr. Taylor.
I was just wondering, am I finished or what do I have to wait still?
No, you still have to wait. I believe that your attorney, Mr. Adams, is headed down to my courtroom. And, so if you'll hold on for him, we'll be with you, okay? All right.
And Your Honor, if I may.
Yes.
Your Honor, I'm ready for a plea on position number 6, and I also needed a breakout room for position number 9. So however the court wishes for me to proceed, I am happy to do so, Judge. Because Mr. Jones is not answering his phone. He's probably using it to be on Zoom, Judge.
Position 6, Mr. Giles. Do I have his paperwork?
I'm sorry, then it's position number 7, Judge. I apologize. I'm going on my calendar.
No worries. But it is Mr. Giles, is that right?
No, I apologize. Position number 7 is Sierra Hosey.
Okay.
That is my case. I'm ready whenever the court wishes. And position number 10, I guess, Marcavis Jones is the one I needed a breakout room. So however the court wishes for me to proceed, I'd be happy to.
Let's do Miss Hosey first and get her complete. So let's do that first.
Thank you, Judge. Ms. Hosey, are you there, ma'am?
Yes, sir.
No, not Mr. Jones, Ms. Hosey.
Oh, I'm sorry.
Sierra Hosey? I see her camera, Judge. May have stepped away clearly, Judge. I apologize.
Okay. Mr. Adams, do you need the paperwork for your client, or how do you plan on getting that filled out? He's on the Zoom call.
I get permission, or you can get permission to sign his name. Will that work?
That's fine. Have you already gone over the paperwork with him, or are you going to need to go over it with him?
We both, we've already gone over with him.
Okay. Do we have his client's paperwork? Whose position of, it's either 19 or 20, Mr.
Yes, Emmanuel Taylor.
Okay, I've got you, Mr. Taylor. I'm trying to figure out who the solicitor is. That
is me, Your Honor, and I'm actually doing the plea paperwork this morning. Mr. Adams and I had agreed, well, he accepted the offer this morning.
Okay,
I'm
so
doing the paperwork now.
Ms. Githier, if you can get that paperwork to Ms. Johnson will get it to Mr. Adams for review, and then we'll go forward with the plea, okay?
Okay.
All right, very good. Okay, so let's get, is Ms. Hosey on with us? Ms. Hosey.
Miss Hosey is on. She appears to be asleep.
Okay, so until she wakes up, Mr. Dodd, we'll put you into the breakout room with, there really must be a full moon today.
I thought I've seen it all, Judge. I'm so sorry.
No worries. Who did you need to go into a breakout room with?
Position number 10, Judge Marquavis Jones.
Okay, let's put him into the breakout room.
Thank you, Judge.
All right, so.
Your Honor,
Yes, Ms. Marshall
we're
Story.
saying position number 10. I know our numbers are off, but you said Marquavius Jones. I feel like
Yes.
that's my case, but I don't have it as position 10.
Right. I have a calendar that has different numbers than everyone else. I apologize. So
No, it may be our mistake.
So it's position number 9 on our calendars, Ms. Marshall Story, position number 10 for the judges. She has an extra one at the beginning.
And that's my understanding that Ms. Gant was going to be handling that.
Yes, and actually, yes, position number 9 is my matter, so.
Okay, all right.
Well, he apparently is not. I checked. Apparently, Ms. Helen never qualified him. They never spoke, which is why I need to speak to him, see if he qualifies.
Oh, okay.
And I'll
So you don't need me right now.
Not right this second, Ms. Marshall.
Okay.
All right. Thank you, Judge.
Okay, so is Mr. Jones on?
He's already in a breakout room.
Okay. All right, so there he goes. Okay, so let's go back, and I appreciate everyone being patient this morning. Let's go back to Miss Askew's case with Miss Marshall Story.
Your Honor, can we go into a breakout room with you? Is that possible?
I would ask not, because I don't know that, are the breakout rooms actually recorded?
Right,
In case a transcript needs to be.
Yes,
transcribed?
unless normally I don't go into a breakout room unless there's something that has to do with mental health or something of that nature. Otherwise, it's an open courtroom. And
That's fine.
Okay, so
I didn't think about the recording.
okay, you're fine, Miss Askew. Let me see. Tell me your client's name again.
Chad Joseph Owens, and he's on also.
13.
Okay. And do I have any paperwork for? Right.
Yes, I did forward the paperwork.
Okay.
Because I thought if we could resolve this issue, someone could just make those amendments and changes in the courtroom.
Okay, so Mr. Owens has been charged in case 20 CR 004108F with battery, family violence, simple battery, family violence, and cruelty to children in the 3rd degree. It's my understanding that there's an issue regarding no-low plea. The defendant has requested a no-low plea. The state has not
We are not consenting to that.
to a no-low plea. As such, Ms. Askew, what is your pleasure?
My pleasure, or my position is, Your Honor, this case is old. It started out the beginning of 2020. The parties are now divorced. They've been divorced almost 3 years. I've spoken with the defendant, I've spoken with the alleged victim. And when I say alleged victim, I mean alleged victim. I'm the one that handled the divorce. There have not been any issues, Your Honor. We've been trying to get this case resolved. My client has never been in trouble before. And I'm not understanding why Ms. Marshall Story, who's been quite difficult to work with, will not accept a no-low. She stated that she spoke with the alleged victim and she has concerns. My client has agreed to take the anger management classes. He has agreed to do the probation. He has agreed to pay the fines. He served, I think he was in jail maybe for about 3 or 4 days. On top of that, the alleged victim contacting my office, begging me to get her husband at the time out of jail, that she made a mistake, and the back and forth, and for him to plead guilty for a family violence that's going, as you stated before with another case, that's going to remain on his record forever and a day. I just have an issue with that unless we can agree to have his record expunged. This man is a business owner, has never been in trouble. He has joint physical custody of their daughter, where he has her a little bit over 50% of the time. And, you know, I don't want this to affect my client, you know, in the future.
Okay. I know that we.
Would you like me to respond?
Oh,
Julia, or would the court like to-
one last thing, Ms. Marshall Story. I asked my client about probation yesterday, Judge Morrow. He has been checking in with probation every Friday since he was released from jail back in 2020. Every Friday he's been checking in with probation. Anytime he has to go out of town, he checks in with probation. So what we're asking for is for him just to go ahead and complete whatever anger management classes the ADA wants, or the solicitor wants him to complete. Let him pay the fine, Your Honor, so he can just move on with his life. He's been doing this probation thing for over 2 years.
So he's probably on pretrial, not probation.
Yes, Your Honor, if I may, I just feel compelled to respond. So the record is clear. And of course, we never want difficulties between parties that are trying to come to an agreement. But Your Honor, as you stated, clearly probation is not involved. Any asks that have been made of the defendant, Mr. Owens, are based on either his bond requirements or they are based on pretrial requirements. I'm not quite sure which one. And I surely don't take the time to do paperwork for a plea unless the attorney tells me the plea wants to go forward. I personally have spoken to the victim in this case. I don't push forward pleas. Everybody has the option for a jury trial. So I'm really not sure where all of this is coming from, because if Ms. Askew's client didn't want to take the plea, I surely wouldn't have sent her the paperwork. And I'm pretty sure I sent it about 2.5 weeks ago, and then followed up to ask, were there any additional issues? I recognize she handled the divorce, but even to hear Attorney Askew refer to the divorce that she handled and refer to the victim in such a way gives me pause. So I'm wondering if perhaps I need to just resend this offer and then we move forward to a trial.
If I can respond, Judge.
Okay.
I stand by what I stated, alleged victim, because I handled the divorce and I know what the alleged victim has told me. I don't know what she has told Ms. Marshall Story, but I have been involved with the divorce since day one. I have spoken with the alleged victim during the divorce case. I spoke with the alleged victim while her husband at that time was in jail, and I know what she shared with me. And I can state alleged victim because whatever she's telling Ms. Marshall Story is not what she relayed to me. Now, Ms. Marshall Story did send over the paperwork, whether it was a week ago or two weeks ago. I've been in court. There was never a discussion about a NOLO. However, Your Honor, if you look at the paperwork, a NOLO is an option. So for Ms. Marshall Story to say, I didn't reach out to her about a NOLO, I don't have to reach out to her about a NOLO. I've reached out to her about other issues. I don't have to. That was an option, and that's the option that my client chose. Now, if he is to take the plea, I want to request or want to ask, is he eligible to have his record expunged? If not, I need to speak with my client. So I think when Ms. Marshall Story is giving the story to the court, she needs to be upfront and honest. I don't have to discuss a no-low plea with her.
But I don't have to make an offer.
Possibly when she
That's
sent over
the
the paperwork, what she should have done was
I don't have to make an offer.
What she should have done is put that her office does not accept no-lows on a battery case. That's what she, or excuse me, a domestic violence case. That's what she could have put, but I don't have to check in with her. She's not my supervisor.
Okay, so this is not a negotiation. And I think all of Ms. Marshall's story is, well, let me start here. I do know that is their policy, Ms. Askew, that they don't.
Yes, sir.
They don't accept no-los with family violence cases. And that's number one. Number two, it's either going to be negotiated or not negotiated. Even something as such as a no-lo, that would be a non-negotiated plea if they're not offering one. That's my understanding. So what I'm happy to do is I'm happy to take a blind plea in this matter, but it sounds to me, Ms. Askew, as you're speaking, that you've got real issues with the alleged victim in the matter, and it might be best just to move forward with either a bench trial or a jury trial on this matter. I think that this might be an excellent case for a bench trial before me in the not so distant future. So I'm happy to entertain that if that's something that you and your client would like also. But you just, you tell me how you'd like to proceed.
Well, my question is, if he does a guilty plea, will his record be expunged? And he's online right now, so he hears, of course, what is going on. I just want to be able to present, I guess, all the options over to my client.
I'm not clear why there's an understanding that a guilty plea will be expunged.
Right, and I don't think the court can answer that question.
Okay, Judge, I'll speak with my client. I'll speak with my client. So I would prefer, if at all possible, I would prefer to deal with another solicitor and try to get the case resolved. Ms. Marshall's story now, we're not getting along, but I'll speak with my client. She's not helpful whatsoever since the beginning, but I'll speak with my client if you can put us in break room.
Okay.
Sure. I'm feeling a bit amiss, but I am always happy if counsel does not believe that I have provided the most appropriate service that I can for our office. I'm happy to actually have this case given to my supervisor or to another member on my team if she believes that will be a better fit for her.
I do.
Okay.
Your Honor, I've worked with Ms. Askew before on a different case. I mean, if she's more comfortable, I don't mind speaking to her about
I'm happy with Ms. Riley, and I'm glad to see you on, Ms. Riley. I'm happy to work with Ms. Riley.
Okay, so where are we? What would you like to do this morning, Ms. Askew?
I want to speak with my client first and go into a breakout room, and then I can come back over if at all possible, if Ms. Riley is still available to speak with her.
Okay, very good. So let's put Ms. Askew and Mr. Owens into a breakout room.
And that's fine, Your Honor, but I'd also like to put on the record that I don't believe that attorney shopping in the solicitor's office is something that would be condoned. But if the court is willing to abide by that, then I will do so.
Okay, well, I have no control over the solicitor's office of what you all do, Ms. Marshall's story. I just want everybody to get along and resolve these cases. So if you don't have any objection to Ms. Riley continuing the representation of the state on this matter, that would be beneficial to the court. And I will also say that I've had very pleasant and forthright dealings with Ms. Marshall's story the entire time that she's been with me. Okay, is that fine with you, Ms. Marshall's story?
That's fine, Your Honor.
Thank you, Ms. Marshall's story. Let's see. Ms. Hosey, good morning.
I'm sorry, Your Honor, do we need to reset a date or are we closing this case out and moving forward to another calendar date?
Oh, she's in a breakout room with her client right now, so I'm holding for her announcement.
Understood. Thank you.
Thank you. Good of you to join us, Ms. Hosey.
I was on earlier.
We were trying to get your attention. Apparently, you drifted off for a moment.
Yeah, I just didn't come in. Once my attorney, my public defender spoke up for me, I kind of was like, okay, we're going back to me. But good morning.
Good morning. Mr. Dodd, are we ready for Ms.
We are
Hose?
ready. We are ready. And Ms. Marshall Story, I sent you a chat on a different case, if you don't mind reviewing it, but I am ready on Ms. Hosey.
What position is that?
So the plea is with Ms. Riley. Oh, she's there. Okay, sorry about that. The plea with Ms. Hosey, which is position either 6 or
It's
7
on the judge's calendar.
So on the judge's calendar is position number 7. Hosey, I'm ready for a plea. Separately, Ms. Marshall Story, position number 9 or 10 on the judge's calendar. Marcavis Jones, I just sent you a chat. So just
Oh,
to
okay.
review.
So
it.
I need to check that.
Yes, ma'am.
Okay,
Sorry about that, Judge. Sorry.
Oh, you're fine.
I'm ready.
Okay, Ms. Hosey, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You can put your hand down, ma'am. Ms. Riley?
Thank you, Your Honor. The state would expect the evidence to show that on September 1st of 2020, officer was dispatched to 2923 Akron Street in Fulton County in reference to a fight call. Upon arrival, he met with the complainant victim, Sinitra Thomas, who advised that she was attacked by her ex-girlfriend, the accused Miss Sierra Hosey. It was then told to the officer that they had gotten into a physical altercation out of state and that the two were going their separate ways, that Miss Thomas was just trying to retrieve her property from the apartment, which contained her travel bag and keys, and Miss Hosey was keeping her from getting her items. And at that time, they began fighting, Miss Hosey attacked Miss Thomas first by punching and scratching her and pulling her hair. The state has amended the accusation in this case, Your Honor, as there was no proof of them ever living together, just being at the same place. And so the state is, Miss Hosey is pleading to count 2, battery, which is 12 months on probation, a $300 fine. She's to complete 6 anger management classes and to have no contact with the victim, Sinitra Thomas.
I'm sorry, has there been a null pros for the battery family violence?
Your Honor, as soon as the plea is finished, I will send the null pros. We just prefer for the plea to be taken before the null pros is sent.
Okay, and on the plea paperwork, it indicates charges, battery family violence and battery. So.
Correct. Those are the 2 charges on the for the accusation.
I think, and I perhaps for clarification, I'm sorry I missed that. The court can cross out to avoid any confusion. The recommendation is as to count 2, which is battery.
Correct.
But I think the list of charges normally, I think a lot of times the state would list all everything that's on the accusation, regardless of whether
they're pleading to that or not. Correct.
But however the court wishes to do that, it's obviously perfectly fine with us, with me.
Okay, I find it confusing, but
I normally would agree. I would agree, Judge.
Is there any objection to me just having the charge of battery on the paperwork?
There's no objection, Your Honor.
Okay, all right. I think that just makes it cleaner.
So are you saying moving forward, you would just prefer that the only charge that they're pleading to is listed? So is there still a need for the null process?
Right, there'll still be a need for the null process.
Okay.
Right. Okay. All right. Anything further?
Nothing from the state, Your Honor.
Okay. Mr. Dodd?
Your Honor, this would be a negotiated plea. This was a very brief relationship between my client and the alleged victim, about 7 months. They never lived together. I believe the batteries is more appropriate. It was a little bit more involved than that, but needless to say, Ms. Hosey does accept responsibility for what transpired on her end. I would just ask the court to follow the recommendation, and if the court would consider waiving the cost of supervision based on her indigency, and potentially suspending probation, not terminating, but suspending upon completion of all the conditions. This way, with the suspension, of course, the stay away stays into effect throughout the period of probation. And I apologize with Ms. Riley. I can't remember if I specifically asked that or not, but I'm requesting the court. So,
any objection to any objection to suspension? I think is the question.
No, Your Honor. Mr. Haddad did send that request via email, and there's no objection.
Okay. And that was your question, correct, Mr. Dodd?
Yes, Judge.
Okay. All right. Anything further?
No, Judge, not as far as this case, Judge. Thank you.
Okay. Ms. Hosey, it's my understanding that in case 20 CR 004589F, you wish to plead guilty to battery. Is that correct?
Yes, that is.
Are you under the influence of any drugs or alcohol this morning?
Okay.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
I do.
Has anyone forced or coerced you to plead guilty? I'll accept the plea as negotiated. I am going to waive the probation fees for you, Ms. Hosey, while you're on probation to help you get and stay on your feet. And once you complete the terms, the probation will be suspended, okay?
Thank you so much. I appreciate it.
Okay, good luck to you, Ms. Hosey.
Thank you, Judge. And I'll fill out the paperwork for probation. I'll be in touch with Ms. Hosey as well as to, I have her email address to email to her and all that.
Okay. And who else do you need to speak with, Mr. Haddad?
Can Ms. Hosey be excused, Judge?
Of course, yes.
Thank you.
Thank you. And Your Honor, I believe Ms. Gant was speaking or trying to speak to the position 1A or 1 Herberto Arias. I don't know. She may have been able to contact him. So she's on the phone with him. My other announcement, Judge, is position on your calendar, position number 10, Marquavis Jones. He does qualify for the services of the Public Defender's Office. I will formally enter an entry of appearance. If I can request a reset, Judge, I'll reach out to Ms. Marshall Story and go from there, Judge.
Okay, September 28th at 9 a.m. work?
And that'd be fine with me, Judge, and I'm assuming it's okay with Ms. Marshall Story.
That's fine, Your Honor.
And Mr. Jones, can Mr. Jones be excused?
Yes, we'll see you next time, Mr. Jones.
Mr. Jones, I'll be in touch with you, but make sure to come back on the 28th of September, okay, sir?
Yes, at 9 o'clock, correct?
Yes, it'll be by Zoom, I believe.
Yes, sir. Thank you.
Thank you, Judge.
Okay, so do we have the plea paper? I know that position, Tyrone Christopher is going to be a plea. Have we completed that plea paperwork?
And
okay.
And Your Honor, the rest of the pleas, I think Ms. Gant has 2 pleas. I will remain here. I am done, but I'll remain in case I need to assist. I don't believe anybody else is waiting for our services, Judge.
Okay.
Your Honor, I have position, I guess it would be 3 on your calendar. Demikio Coleman, I guess that came into the courtroom.
He still got to pay the music.
Okay. And he has requested a public defender also.
I was not aware. Thank you, Ms. Riley. And if I can get a phone number from Mr. Coleman.
As soon as he comes back into the court, we'll get that for you, Mr. Dodd.
And I'm sorry. It looks like I just got a text from Ms. Gantz saying that Mr. Coleman does not qualify for the services of the Public Defender's Office. I guess she spoke to him.
Okay.
He stepped out to pay the meter.
But I'll remain, Judge.
Thank you, Mr. Dodd.
Judge,
Yes.
I'm sorry, this is Attorney Askew. If Ms. Riley is available, can I speak with her in a breakout room, please?
Okay, Ms. Riley, and we will put Ms. Riley and Ms. Askew into a breakout room.
And Your Honor, just so you're aware, I believe both pleas with Ms. Gant are mine. So.
Okay.
Is it good? Okay. He in the back. I think he like 20 something. I don't remember what number. Position 20.
Mr. Adams, are we ready to take the plea for Mr. Taylor? Yes, sir.
Mr. Adams, come right here for us, okay? Come to this.
This is position 19 and 20. Is this your case, Ms. Marshall, or is it Ms. Githiea's case? Emmanuel Taylor.
This is mine, Your Honor.
Oh, there we go. There we go. Yes, Mr. Adams.
Yes, Your Honor, this is a negotiated plea as stated. One of the parties is a $400 fine. I just wonder if we can convert that to community service.
Okay, Ms. Githia, did you hear that, Mr. Adams? He would like to convert the $400 fine into an additional 40 hours of community service. Does the state have an objection to that?
No objection to that, Your Honor.
Okay, and does anybody have an objection to me changing it to 40 hours on the plea sheet?
No, yeah.
Okay.
No, Your Honor.
All right, good morning again, Mr. Taylor. Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you, sir. Ms. Githia?
Yes, Your Honor. On August 3rd, 2019, an officer was dispatched to 85 North and Buford Highway in Fulton County to help an impaired driver that was in a car accident. When he spoke with the driver, later identified as Mr. Emmanuel Taylor, he asked him to exit the vehicle. When he did, he lost his balance and fell into the back of his vehicle. The officer smelled a strong odor of an alcohol beverage coming from his person and observed bloodshot and glassy eyes and slurred speech. The officer then conducted the sobriety test. The clues for the HGN, I'm sorry.
No, don't speak loud.
Yeah,
Mr. Taylor, you have a right to remain silent. Anything you say can be used against you, okay? So Mr. Adams is here on your behalf this morning, and I suggest that that you let him speak on your behalf, okay? I'm sorry, Ms. Githia, you can continue.
The clues for the HGN test were 6 out of 6 clues. During the walk and turn, Mr. Taylor had a hard time keeping his balance and did not touch heel to toe on any of the steps and stepped offline several times. Based on all of this, the officer placed him in handcuffs. The offer is 12 months to serve 1 day, credit for time served. It's going to now be a total of 80 hours of community service, alcohol drug evaluation and treatment, a risk reduction program, 1 victim impact panel, and restitution in the amount of $1,564.
Mr. Adams?
Yes, Sean, that is a recommendation, but we have agreed to keep the restitution open. We can provide proof that the damage was covered by Mr. Taylor's insurance. We can't do it today, but we can do it this week.
Yes, once I receive a receipt, I will make a note of that, and then we can say that portion has been completed.
Okay.
And you know, why he doesn't agree with all the facts, he does want to resolve this. So we'd ask you to accept the recommendation.
All right.
I'm not satisfied with that because it's a lot of lies going on there. And the whole statement about me staggering around and stuff, that is completely not true.
Mr. Taylor,
I don't know.
I told you.
But that whole story is
I
not
just told the judge that. I just told him you didn't agree with all of the facts.
Yeah.
Do you need to speak with him in private, Mr.
I might
Adams?
want to fight this because that don't even make sense. Like none of that stuff happened.
Yeah, we can.
Again, Mr. Taylor, you have the right to remain silent. Anything you say can be used against you. At this point, Mr. Adams, I'm sorry, I don't feel comfortable taking the plea, given that he is that he is telling the court that that he's not, basically that he doesn't feel that he's guilty. So if you want to speak with him, I can reset this for another time. If you want to speak with him, if you want me to set this down for a bench trial before myself in the not so distant future, or a jury trial, I'm happy to entertain that also.
We accept the North Carolina versus Alford plea.
Is there any objection to an Alford plea, Ms. Scipio?
No.
I'm sorry. There's no objection, Your Honor.
Okay. We will accept an Alford plea on the matter if that's what your client wants.
Okay. You want to talk to him now? Or?
Why don't you give him a call and explain it to him?
Okay.
And then come back and let the court know.
Okay, I'll be right back.
So, Mr. Taylor, Mr. Adams is going to call you to explain some things to you in private. Okay.
Yeah, because
Okay, Mr. Taylor. Again, you have a right to remain silent. So speak with your counsel. Okay.
Okay.
Okay, so Miss McLeod, it's my understanding that Miss White, who is position 23 or 24 on the calendar, is requesting a jury trial. Is that correct?
Yes.
Okay. So we will get you the case management order and a formal request for the jury trial. Okay. We'll get you that before you go. So you'll just have that, if that's all right with you.
Thank you.
And can your client be excused? Anything further for Ms. White?
Nothing further.
Okay. Let's see, Ms. White. Yes, Ms. McLeod will be in touch with you, and you will get notification of your next hearing date on this matter. Okay.
Thank you so much.
All right. You have a good day, ma'am.
You too.
Thank you, Ms. McLeod. We'll get that paperwork to you.
So I should just wait for the order.
Yes, just wait. We'll get it to you momentarily.
Thank you.
Okay. Let me go back to Mr. Coleman.
So it's Mr. Giles, he's right here. Yes, sir. Mr. Coleman still has an attorney.
Okay. So Ms. Riley has not returned, so we cannot take any of the pleas right now.
Yes, Mr. Adams.
Okay. All right.
Or does not have an issue of appearance.
Mr. Colbert.
Yes, sir.
Mr. Colbert, we do not have an entry of appearance for your counsel, Thomas Stewart. I am going to reset you until September 28th. Have Mr. Stewart enter a notice of appearance, and he is to at least contact the court prior to that time to let us know that he represents you. Okay.
Yes, sir. Question, Your Honor.
Yes, sir.
What if this case? Is it feasible? I'm just asking a question, because I don't know. If I like to know. Anyway, information. If it gets, can it get handled before that court order date? Is it feasible? Is that possible? If he comes in and say, okay, can we take care of it?
There's a possibility that we can reschedule this for an earlier date, but your counsel is going to have to request that.
Yes, sir.
I'm going to give you a date today so that we have a date certain that you're going to be back here. And let me just say that if you come back and you don't have an attorney, I need for you to be prepared to move forward with the case. Okay.
Okay. Yes, sir. No problem.
All right. So you'll get notification of the September 28th date. And unless you have any other questions, you have a good day.
Yes, sir. You as well. So my next court date will be September 28th, right?
Yes, at 9 o'clock. You'll get notice.
Okay. All right. How long does it take that notice to get here? I do want to ask that also.
That I don't know when the notices are going to go out at this point in time. I'm sorry, Mr. Culver, but
okay.
You'll get it. You'll get it. Well, I'm giving you verbal notification right now, but you're going to get notification by mail very soon. Okay.
Yes, sir. Okay. Hope we won't get here around the 23rd or 21st. And
no, we're gonna give you time. Okay.
Okay.
All right. You have a good day, sir.
Yes, sir. Yes, sir.
Oh, okay. Thank you. Okay, and I believe that we are waiting for Miss Riley to return so that we can take some pleas.
Somebody bring your copy.
I'm sorry, I can't hear you, Miss Gant.
No turning on. You're gonna have to speak up. It's giving feedback.
Okay, thank you, Your Honor. I do have an announcement for position 1, Mr. Arias. He does not qualify for the services of the public defender's office.
Okay.
And I believe Mr. Haddad gave an update with the same announcement for position number 3.
Yes, he did. Mr. Coleman has not rejoined us in court yet. Mr. Herberto, can you unmute for me?
Yes, sir.
Good morning again. It's my understanding you do not qualify for the services of a public defender today. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. If you need time to hire an attorney, I'm happy to give you that opportunity. You have been charged in case 20 CR 003632F with simple battery family violence. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. You have the option of pleading guilty to the charge, and I'm happy to let you know what the solicitor is recommending if you enter into a guilty plea. You also have the right to enter a not guilty plea. If you enter a not guilty plea, you can have a bench trial, which will be before me in the very near future, and you do have the right to have a jury trial. The jury trial will be your case will be returned to the division judge, and you get notification of when that jury trial is going to be. What would you like to do this morning, Mr. Herberto?
I would like to request a reschedule.
Okay, to get an attorney. Okay, so I'm going to reset you for September 28th at 9 o'clock. You will get notification. I would suggest if you go ahead and get an attorney as soon as possible so that they can begin representing you and defending you on this case. They will also need to enter a notice of appearance on your behalf prior to the next hearing date so that the court knows that you are represented. If you come back on the 28th and you are not represented by counsel, you will have to be prepared to move forward pro se, which means without the advice of a lawyer, okay? And you're gonna have to tell me at that time how you wish to plead to these charges.
And
You have any questions for me?
no, Judge. Thank you.
Okay, we'll see you back on the 28th, sir.
All right, thanks.
You're welcome. Have a good day. And we are still in recess until Ms. Riley gets back with us. Mr. Haddad, I appreciate you being here for the court. I think that Ms. Gantz indicated that she can handle the rest of the calendar if you would like to go on with your day.
Great. Thank you so much, Judge. I appreciate it.
You're welcome. You have a good day. Thank you so much.
Bye-bye.
Your Honor, Mr. Haddad's client is here in person. Position, it's our position number 21.
Apparently someone has shown up.
Oh, Felice, is that Thomas?
Yes.
Yes.
She's in person.
Okay, Judge, I wasn't sure if she was on Zoom this morning, but I had made an announcement for a bench trial for her.
Right.
So,
So
I'll be in touch with her, of course.
Okay, Ms. Thomas, good morning. Mr. Haddad has requested a bench trial on this matter. That bench trial is going to be on October 26th at 1:30. You'll get notification, okay?
Okay, thank you.
All right.
See you later.
All right.
Ms. Thomas, you have to appear in person and please be on time, okay? Yes, I will. Thank you.
Yes, Mr. Adams. Okay, and that's going to be an offered plea?
Yeah.
Thank you, Judge.
You have a good day, Mr. Haddad. And on this matter, is the following too closely, is that a plea or is that a no pros? Mr. Taylor.
That was not no posture.
That's gonna be a plea also?
Yes.
Okay, thank you. Okay, are you with me, Mr. Taylor?
Yes, sir.
All right, very good. And since we've taken a break, let me just go ahead and swear you, make sure that we've sworn you in, okay? Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court, read the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you. We have already heard from counsel in this matter. And it's my understanding, Mr. Taylor, that you wish to plead an offered plea in case 20 CR 004552F to driving under the influence of alcohol, less safe, and following too closely. Is that correct?
Yes, sir.
Are you? You're gonna have to come on camera for me, Mr. Owens. I'm sorry, not Mr. Owens, Mr. Taylor. I see you there. It's my understanding that you do wish to plead offered to those charges. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and not by pleading offered to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to enter this offered plea?
No, sir.
Okay. I'm going to accept the plea as negotiated. Mr. Taylor, I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And was there a request regarding once the terms are completed, what you'd like to do with the probation, Mr. Adams?
Yes, we'd like it to become non-reporting.
Any objection to non-reporting?
No objection.
Okay, and once you complete the terms, Mr. Taylor, the probation will be non-reporting, okay?
Oh, okay. One more question, Judge.
I don't know if I can answer it. You might want to.
I can answer when you call me on the phone.
No, it was regarding community service. I can do community service.
You'll speak with the probation department, Mr. Taylor, and they will explain it. Explain the probation and the community service to you. Okay.
Okay.
All right. Good luck to you, Mr. Taylor.
All right. Thank you.
Thank you.
All right. Thank you, Mr. Adams. Good to see you.
Mr. Adams, we need you to fill out something before you use probation sheet.
Okay. Welcome back, Ms. Riley. Let's see. I will start with, were you and Ms. Askew able to resolve anything?
Yes. Yes, Your Honor.
Okay, so how are we proceeding?
The state would like an opportunity to just get a little further information, but we do believe we'll have a resolution if we could just have one continuance, Your Honor.
Okay, so does that September 28th date work?
Yes, sir.
I think that's what we agreed to. Let me look at my calendar, Judge. Yes, that works for me. And it was great working with Ms. Riley. So hopefully we can try to get it resolved.
Okay, I'm glad that you all were at least able to talk. So September 28th at 9 a.m.
Yes, Your Honor. Will we receive a Zoom notice?
Yes, you will. You will, Ms. Askew.
Okay. We appreciate you. Thank you so much,
No
Judge.
problem. You have a great rest of your day.
Okay, thanks, Ms. Riley. Y'all have a good one. Mr. Owens, I'll call you.
And Ms. Askew, if you all do come to terms, all this paperwork that I got today, I'm going to shred that. So if you wouldn't mind, whatever terms you all come to, get that to the court prior to the next hearing if you do come to terms.
Yes,
I
sir.
will send new paperwork. Yes, Your Honor.
Okay, thank you.
Thank you. Bye-bye.
All right, so we have Mr. Christopher and Mr. Giles. Okay. So let's do Mr. Giles first. Mr. Giles, if you come up to the.
Okay, come back when you're done.
And Your Honor, just give me one moment. I had Mr.
They have to bend down. They should be able to give you just
Christopher's paperwork up. So give me just a
Oh,
second.
okay. I can do Mr. Christopher if that's easier for you, Ms. Riley.
It'll just take me a moment, Your Honor.
Okay,
To pull
all right.
up the police report.
Coleman ain't came back yet. And we don't take that long to pay for it.
Ms. Gant. I think he needs to sign this.
I'll get it, y'all.
No, she signed it. He needs to sign it.
All right, this your guilty plea form. What about the circles? Yes, no? You need to go through the circles? Okay, do me a favor, read all this. You gonna either circle yes or no, okay?
Your Honor, I'm ready when the court is.
Okay. Thank you. Mr. Jones, can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. You can put your hand down. Ms. Riley?
Thank you, Your Honor. The state would expect the evidence to show that on June 29th, 2019, officer was dispatched to 2060 Allison Court in Fulton County to a damaged property call. Upon arrival, he spoke with the victim, Miss Mary Henderson, who advised that her boyfriend had thrown an object at the window of her bedroom and damaged the screen to the window. She advised he admitted to doing it and as a result or in response to a dispute they had earlier that day. No further injuries were reported or advised of. The state's recommendation in this case is 12 months probation, 3 anger management classes, and he has had no contact with the victim, Miss Mary Henderson, and there is no early termination of this probation, Your Honor. And the state does not have an objection to a no-low plea.
And I have on the paper, non-reporting upon completion of conditions.
Yes, Your Honor.
Ms. Gant?
Thank you, Your Honor, and I would ask that we waive any probation fees.
Okay, anything further?
Yes, Your Honor, Mr.
Ms. Gant, they may not be able to hear you on Zoom, so you may have to stand next to your client.
Thank you, Your Honor. Mr. Giles is prepared to move forward with a negotiated no-low plea today.
Okay. Mr. Giles, it's my understanding that you wish to plead no-low in case 20 CR 0041119 after criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading no-low to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead no-low?
No.
I will accept the no-low plea. Mr. Giles, I'm going to waive the probation fees for you to help you get and stay on your feet. And once you complete the term, you'll go to non-reporting status, okay?
Right.
All right, good luck to you, sir.
Thank you, Your Honor.
Okay, are we ready on Mr. Christopher?
Oh, you had to go to.
Yes, sir.
Mr. Christopher, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Thank you, sir. Ms. Riley?
Thank you, Your Honor. Just one moment while I pull it up.
Okay.
Thank you for the time, Your Honor.
No problem.
The state would expect the evidence to show that on June 29th, 2019, officer responded to 317 Skipper Place in Fulton County in regards to a domestic dispute. Upon arrival, officer was met, excuse me, with says the victim's daughter, Miss Tyra Christopher, and Miss Tyra advised that her parents, Mr. Tyrone Christopher and Miss Antoinette Christopher, had been in a dispute in which Miss Christopher had to defend herself against Mr. Christopher. Mr. Tyrone Christopher, during the dispute, advised that Mr. Christopher had been drinking and became upset. And while they were in the bedroom arguing, she was pushed multiple times, in which caused her to, looks like grab a gaming cord and swing it at Mr. Christopher, striking him with the cord in self-defense. The state's recommendation is 12 months probation, a $200 fine or 20 hours of community service. He is to attend and complete 2 anger management classes, as well as a drug and alcohol evaluation and any treatment that is recommended. And the state does not have an objection to probation becoming non-reporting upon completion.
And I've got no further violent contact with Miss Christopher.
I apologize. Yes, Your Honor, no further violent contact because they are still married.
Okay. Anything further, Ms. Riley?
Nothing further from the state, Your Honor.
Ms. Gant,
Thank you, Your Honor. We asked.
you want to come back up? I'm sorry.
Thank you, Your Honor. We agree with the state's recommendations and ask that you accept the plea as offered. And Your Honor, also, if we may ask if Your Honor has not granted to waive probation fees.
Okay. All right, thank you, Ms. Gant. Mr. Christopher, it's my understanding that in case 20 CR 00448-1F that you wish to plead guilty. I'm sorry, it's a simple, Ms. Riley, the calendar said it's simple battery family violence, is that
That
correct?
is correct, Your Honor.
You wish to plead guilty to simple battery family violence, is that correct, Mr. Christopher?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, I am.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Christopher. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
Yeah, yes, sir.
All right, good luck to you, Mr. Christopher.
All right, thanks.
I'm sorry, Ms. Gant, does Mr. Christopher want the fine or the community service?
May you clarify, we discussed the fine, but Mr. Christopher, may you clarify if you would like to do the 20 hours or the $200 fine?
So, Mr. Christopher, you have the option of paying a $200 fine or doing 20 hours of community service. Which do you prefer?
The 20-hour community service.
Okay. Does anyone have any objection to me changing on the plea sheet the $200 fine to 20 hours of community service?
No objections from me.
Okay. All right. Good luck to you, Mr. Christopher.
All right, thanks.
Is this Mr. Coleman?
Yes,
All right, come on up, Mr. Coleman.
come on, from
I'm free to go.
Do you need anything further for Mr. Christopher, Ms. Gant?
Nothing further. Your Honor.
Okay, you have a good day, Mr. Christopher, yes,
All right, you too, thanks.
thank you. Good morning again, Mr. Coleman.
Hey, good morning.
It's my understanding that you have made application with the public defender and you do not qualify for their services. You have been charged in case 20 CR 004176F with simple battery. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. I'm happy to let you do, if you want to seek counsel regarding this matter, I'm happy to give you the opportunity to seek counsel. If you want to hear what the state's recommendation for a plea of guilty is in the case, I'm happy to let you hear what the recommendation is. You can also plead not guilty. If you plead not guilty, then you can have a bench trial before me in the not so distant future, or you can request a jury trial. In the case of the return to the division judge, and you'll get notification of your next hearing date. What would you like to do this morning, sir?
So I'm a little confused because everything that we just did right just now, we already did this a year ago and I pleaded not guilty.
Okay.
So we did this on Skype a year ago.
So what's happened is that the division judge, we have what's called an Orca calendar now, and so we're trying to see if we can move some of these cases along. So the division judge has returned the case or has given the case to the Orca calendar to see if we can get the matter resolved. So if you want me to return it to the division judge and you want a jury trial, then that is certainly your right. So
Because I'm a little confused, because this is really not a simple battery case. This was really missing.
let me
Can I state on my statement?
Well, I just want to advise you, because a lot of times people want to speak for themselves and they don't understand that they're getting themselves into more trouble than they are getting themselves out of trouble. Okay, so
Well, I used to be an officer too, so I know how to go.
okay, so you do have the right to remain silent. Anything you say can be used against you. You have solicitors that are on the line that are listening to everything you say and will be comparing it to what they have. So, so I'm happy to hear what you have to say, but I want to make sure that you understand that that what you say is they're listening to also. If you want me to get their recommendation, if you want to speak with the solicitor, I'm happy to give you that opportunity also.
So the first one you said, the bench trial, is that what you said?
Yes, if you request a bench trial, that'll be in this courtroom before me, and that bench trial will be set for October 26th.
So can we do that?
You want a bench trial?
Yeah, we can do
Okay,
that.
so did you hear that, Mr. Riley? He's requesting a bench trial. That bench trial will be on October 26th at 1:30. It's going to be in person here. So if you have any witnesses, if you have any evidence that you want to present to the court, you need to have that with you at that point in time. It'll be up to states to prove their case beyond a reasonable doubt, and you'll have the opportunity to cross-examine any witnesses that they have or any evidence that they have, okay?
Okay.
You have any other questions for me this morning?
So I won't have to have a public defender or attorney for that particular court?
Yes, if you want to, you don't qualify for the services of a public defender, so you won't have a public defender. If you want to hire counsel before that time, I suggest that you go ahead and as soon as possible hire counsel so that they can begin working on your case for you.
Okay.
And so if you come on October 26th and you don't have counsel, then you will have to proceed pro se, meaning without the advice of counsel, okay?
Okay.
So we're giving you ample opportunity to get counsel if you need.
Gotcha. Okay. Gotcha. Okay.
So the case will be proceeding for, if you come in and you don't have counsel, the case is, and you've requested a bench trial, the case is going to be going forward on that day, okay?
On that day. Okay, gotcha.
Okay, any other questions for me?
That's it.
All right, you have a good day, sir.
All right.
Okay, so I think that completes the 9 o'clock calendar. I think we've taken care of everyone. So when Ms. Johnson is ready, we'll go over the calendar. I appreciate you all being so patient today.
Verify, make sure that's good. You'll sign, okay?
This needs to be changed.
Address?
Yeah.
Okay, hold on.
Because y'all sending a letter or something.
Oh, it's up to him to inform the court, so.
His address is different, so I'm gonna write it, have him right out here. Mr. Coleman, come on.
Can everyone hear me? All right, so position one, just gonna call the names. Arias was a reset to 9/28. Christopher was a plea. Coleman was a bench trial. Colbert was a reset to 9/28. Gibson was a plea. Giles was a plea. Posey was a plea. Howard was a bench trial. Hutchins is a bench warrant. Jones is reset to 9/28. Oh, Martavius Jones is reset to 9/28. Tiara Jones is reset to 9/28. Marks is reset to 9/28. Owens is reset to 9/28. Pittman is reset to 9/28. Jordy Quinez is a non-plus. Rucker is 9/28. Schneider was no answer. Was a hope for report for the attorney.
Let's give him one additional opportunity. Since he does have counsel, if we can get in touch with counsel to find out why he wasn't here today, we'll reset that to September 28th.
Schneider reset to 9/28. Soto reset to 9/28. Swan reset to 9/28. Taylor was a plea. Thomas is a bench trial. Galade Jail is a plea. Rosanella is a 9/28 reset. Betty White is a jury trial. And Wood is a bench warrant. Any questions?
Questions, concerns?
No, thank you, Your Honor.
All right, thank you all. You have a good rest of the day. We'll see you next time.
Thank you.